The interview of Mark McCormick was conducted on December 15, 2005, as part of a project for the Friends of the Iowa Judiciary. Former Justice McCormick served as a justice of the Iowa Supreme Court from 1972 to 1986, almost 14 years. We were fortunate to have as the interviewer Mark Shantz, who teaches at the University of Iowa College of Law and has been in private practice in Iowa, served as Solicitor General of the state of Iowa, and as General Counsel to the University of Iowa.
Well, Mark, thank you for agreeing to do this. I think many people will be interested in what you have to say about some of these things. Why don't we start by telling folks a little bit about your early life, how you, we'll see whether there's any connection between your early life and your later life.
Well, I was born in Iowa, in Fort Dodge, to parents who were born in Webster County, Iowa. They were products of the Depression. My father was a self-educated lawyer. He was a member of the last group that was admitted without ever having been to law school. The examination at that time was largely oral, but he had been Webster County recorder for 8 years and then took the bar exam based on what he had picked up over the years, pretty much. My mother was a teacher. She had taught in elementary school, actually starting in a one-room country school, teaching back in the early 20s, and ended up with a teaching career that spanned about 50 years. My father died relatively early. He was 47. I had 3 brothers. We grew up in a very normal household. My mother said, whatever you do, don't be a teacher, it's too hard, pay isn't good. My dad said, whatever you do, don't be a lawyer. He always wanted to be a doctor and hadn't been able to achieve that ambition, mostly for financial reasons. But I did end up drifting into law school. Went to the public schools in Fort Dodge, then went to Villanova University near Philadelphia on a Navy ROTC scholarship. Went from there to 3 years in the Navy, served on a destroyer, mostly in the Mediterranean. Then took the law school admission test just because I wanted to retain my options about alternatives, and did apply to Georgetown Law School. I had been intending to apply to a couple of others, but I got a letter back from the regent saying, if you come to Georgetown, we'll give you a full tuition scholarship. So I went there, thoroughly enjoyed that experience. I went through a 2-year program and got out in 1960. I was looking for work. The idea of a law clerkship appealed to me as a way of making a transition into practice. So I ended up meeting with and applying with Harvey Johnson, who at that time was Chief Judge of the 8th Circuit with his office in Omaha. He offered me employment, so I ended up in Omaha clerking for him for about a year, and then made it back to my hometown to practice for
well, let me go back over a few of those things. And so in high school you hadn't started thinking about being a lawyer particularly, I take
Not really. I went down to my dad's law office a few times because he used me during tax season to type depreciation schedules. And I liked, there was something about the atmosphere there, and I did like it. I just liked being with the books. I liked being around an old-time lawyer named D.M. Kelleher, who was a giant of the bar, who practiced shared office space with my dad and his partner. So I thought about it a lot and was involved in debate in high school and in college, so that the kind of analytical work that a lawyer does appealed to me. But actually, when I went to college and graduated from college, I was thinking about the law, but I was also thinking going back to graduate school and maybe ending up as an English professor somewhere. I was interested in that field, but I really, as I say, I kind of drifted into the law, although I had some reasons for being attracted to it, and I've never regretted it.
The debate, you do that at a competitive level?
Yes, yes. Yeah.
Now, I'm known as a grown-up, you're pretty well known for often seen running the streets of Des Moines. Is that a habit that started in high school?
Well,
a track person?
And I really wasn't. I did play basketball for a while and played some intramural athletics, but actually got attracted to running when I was in law school. I felt I needed a break, so I would go over to a track. In fact, it's the area where the current Redskins Stadium is, and run around there just for exercise. I did, I guess, in college also run with a friend who was on the baseball team, and he wanted somebody to work out with. He would also have me pitch batting practice to him, but we would run around the track together. It really was not until I moved to Des Moines in the 70s that I got into enjoying running as a regular recreation.
How did Georgetown Law School get on your radar screen?
I had been to Washington, D.C. both when I was in college and when I was in the Navy. I loved the city. And also just knew that the school had some reputation. I didn't know what part of the country I would end up settling in. I knew it was a national school.
Sure.
And so I had taken out catalogs or gotten catalogs from Stanford, Harvard, and Georgetown, and I had intended to apply to all three, but that process got short-circuited when Georgetown expressed some interest in me. I actually enjoyed that experience a lot. I think being in the nation's capital was a tremendous advantage because it is a city of courts. I got to go down and watch the Congress. I watched the Senate in a civil rights filibuster, went over and watched the Supreme Court, got to see some arguments in some fairly significant cases.
I had an experience clerking for a judge that impacted my life a little bit. Tell me a little bit about your clerkship experience.
Harvey Johnson was an amazing individual. He had served on the Nebraska Supreme Court before being appointed by President Franklin Roosevelt to the Eighth Circuit. And he was a very intense, very bright, very hard-working individual. Had a disability, but he didn't really let that stop him. It just gave him a limp that he coped with. But it was more his working habits than anything else that impressed me. He did, on one occasion, ask me to see what I could do in drafting an opinion. And so I drafted it. And he called me in afterward and said, "You did this very well. It looks very good. It's not quite the way. It's not quite the way I would write it." But he did take that work product and he turned it into his own opinion. But it was not his practice to let law clerks drafting. I mostly did memoranda for him. I also organized the law library for the Eighth Circuit at that time in Omaha. The courts had just moved from an old building into what was then a new building. And they just dumped all of the books on a group of tables in what was the new library. And my first assignment for 6 weeks was to put that library together.
Were there oral arguments in Omaha?
Yes, yes. In fact, Harry Blackman was there on occasion, and some Iowa lawyers were arguing cases. I remember seeing Lex Hawkins over there.
And what, Judge Van Oosterhout would have been the Iowa?
Yes,
judge?
yes.
And was that 1 year, or did you?
I stayed just 1 year.
1 year, one
Yeah.
clerk, 1 year?
Yes.
That's a little different than they do it now.
That's right. Not as many and not as long. Although I could have stayed indefinitely, I was itchy to get into the law practice, actually. And so I had gone up to Fort Dodge, talked to some lawyers there about the potential of coming back there to practice, and a firm made an offer to me. I talked to Judge Johnson about it, and he was willing to have me stay, but he saw the fact that I was interested in getting started in practice.
And which firm was that?
Actually, it was the firm of Burnquist, and Kirsten. The Burnquists had been railroad lawyers. The Illinois Central Railroad ran through Fort Dodge, and Burt Burnquist was a well-known trial lawyer. Don Kirsten, I think, became fairly well-known.
Yeah.
Maybe maybe more because he was a balloonist, hot air balloonist, but he was a good fellow.
A natural hobby
Yeah.
for lawyers, some would say.
Yeah, and we ended up actually merging with another law firm after I was there about 3 years. Actually, Don left our firm, and I went with the Burnquists to merge with Art Johnson and Ed Flattery into what was then a 4-person firm, and the firm still exists in Fort Dodge and has, I think, about 10 lawyers now.
And what was the nature of your practice in Fort Dodge?
Yeah, about everything. It was a general practice with an emphasis on trial work, and I was the lawyer that did the appellate work in the firm. I had read James Gould Cousins' book, The Just and the Unjust, and it gives sort of an idealized version of a county seat lawyer, just a lawyer in ordinary practice taking on what in that book was a major case, but struggling through it. And you see the human side of the practice. And I thought what I would do is just get as much experience in a variety of areas as quickly as I could. I really was inspired to do that too by Harvey Uhlenhop, who was on the district court at that time. I still remember my conversation with him. We were sitting at a table like this, and he was asking me questions and talking to me, and he said, my advice to you is get your feet under the counsel table. and I've never forgotten that, and I took that advice, and I was involved in just almost every nature of trial. Tried one case where our recovery was $17.50, another case to a jury where our recovery was something like $350. Tried criminal cases as a prosecutor for 4 years, including a couple of homicide cases. Just thoroughly enjoyed the experience. Handled some appeals where you got paid $25 for handling a felony case, and really had some enriching experiences in those times in all areas of the law. Did probate, wrote wills, handled divorces, got involved in bankruptcy court, just about everything one can encounter in a general practice. But really kind of gradually got more involved in the litigation side of things.
Any one big case you remember particularly from your practice days?
There are several cases that ended up in the Supreme Court. I think my major prosecution was a case involving a defendant named Ronald Grimenz. And State against Grimenz is in the books. That was the case in which the Iowa Supreme Court ended up adopting the doctrine of diminished responsibility. It was a murder case where the defendant got convicted of murder. In fact, my future partners, Art Johnson and Ed Flattery, defended that case, and it was on the basis of getting to know me in that case that they tried to attract me to their firm later, so it meant that too. But that was a significant case. I did get a reversal in a case for an indigent in my first criminal appeal prior to becoming a prosecutor, State against Cameron, and that was an interesting experience too. I had some civil cases, some personal injury cases that ended up on appeal, and one, let me just tell you this because it's an interesting legal issue as well. I represented a young man who was a passenger in a car that was going north at night on a county blacktop road. The driver did not see an Angus cow in the middle of the road, hit the cow. My client ended up, his head hitting the windshield, falling back against the seat.
Before seat belts, huh?
Before seat belts, and injured himself. But the impact knocked the lights of the car out. As they were just starting to wake up after the impact, they were rear-ended by a car that was coming north on the same blacktop. So he went up against the windshield again and hit his head. And he decided he'd better get out of the car. So he got out of the car and he headed for the ditch to the west, and he saw a car coming toward the accident scene. So he hurried into the ditch. The car coming from the south, saw the accident scene, and headed for the ditch, same ditch he was in. Hit him, threw him 30 feet through the air, and he hit his head on a fence post. So he had 3 impacts on his head from that single series of incidents.
You have a causation issue.
We had a case in which the doctrine of indivisible injury was involved, and that was a lot of fun. We did ultimately make a recovery in that case.
And before too long, though, you were attracted to the district court bench?
Yes.
How old were you at that time?
Well, actually, I first expressed interest in it when I was 33. And I had been 27 when I started practice, so I was just really 6 years into practice when I got interested in it. My partner, Ed Flattery, was interested too, and Ed ended up getting appointed to the bench before I did. But I did get appointed when I was 35.
So was this something you thought about a long time, a dream, or just as you got closer to it?
It was part of idealizing lawyers and judges, and I think I developed the ambition just by having been around judges and courts.
Was the process similar to what it is today in terms of the nomination? And
Yes, yeah. Iowa had moved to this Missouri Plan selection system just a few years before. Actually, I was appointed in 1968, and I think the system had been initiated in about 1962.
So who was governor? Was that?
That was Governor Hughes.
Yeah. Well, tell us a little bit about your district court experience. District court judges in Iowa do a lot of things.
Yeah.
What part of it did you like best and what least?
I liked it all. When I was first appointed, Harvey Uhlenhop was our chief judge. Again, I had a great deal of respect for him, and in many ways he was a mentor, intellectually at least, about the law. And he had the idea that I should be a roving judge, that I should go around the district and try difficult cases. And so that attracted me. I thought that would be fun. And the interesting thing is that, and he commented on this to me, the pace of activity in practice is more intense and more hectic than it is on the bench, even now. Hours are more regular for judges. There's more time for reflection, even though trial judges have less time than appellate judges. And I was finding I really needed to keep active. I needed something that was challenging, and sitting through a 3-hour hearing about modifying child support was not my idea of the kind of activity or excitement that I wanted to have. So I did get sent around the district to try cases occasionally that were specially assigned because of their complexity or difficulty, and I thoroughly enjoyed that. I also participated in the regular rotation, and I just loved getting into the different counties. Every county in the district had a separate, unique legal culture locally, and getting to know the lawyers and the bar was a good part of the satisfaction.
How far west did your district go?
That was the old 11th district, and it didn't go west of Fort Dodge at that time, or Webster County. It went east as far as Franklin County and Hardin County, and south as far as Story County. But it was a 7-county district that was relatively compact, but involved considerable travel from Fort Dodge on the days I went to Franklin County. In fact, Harvey Uhlenhop suggested to me. Yes, yeah. When Harvey talked to me about coming to Franklin County, he said, "Bring a book." So there was not quite as much.
I tried a case in Franklin County once. I know it. But were any particular lawyers or particular trials you remember from that period of your life?
Well, I really had a number of enjoyable experiences. I enjoyed Alan Loth from Fort Dodge, who was another one of these giants of the bar, a tremendously bright lawyer. He had authored the book on civil procedure at that time. He had taken Cook's book and had updated it. He was, in many ways, a strong influence on me. I spent a good deal of time visiting with him on occasion, and I handled cases opposite of him, and also just made it a point to get to know him professionally quite well. He was an outstanding lawyer. My partner, former partner, Art Johnson, was a tremendous lawyer and had a number of significant cases. John Butler from Eldora, tremendous lawyer. Carl Smedall from Ames, just a great lawyer too. Just generally, I thought the bar was impressive. There was a young lawyer from Alden named David Hanson that I would run into in Hardin County. I didn't imagine at the time that he was in my court that he would end up himself in the judiciary and eventually on the Eighth Circuit. But one of my most interesting trials was an early trial involving a nuisance claim that was tried in Hardin County. We had, on the plaintiff's side, Jack Weitzel from Iowa Falls, who was a good lawyer, along with Carl Letts. On the defense side was John Butler, who was a tremendous lawyer from Eldora. It was a hotly contested case involving the issue of whether or not keeping cattle in a feedlot on what was an abandoned gravel pit about 800 yards from a little town, an unincorporated town called Gifford, was a nuisance or not. So we listened to a lot of evidence, and it was a bench trial. And with good lawyers, it was particularly enjoyable. The defense called, as I recall it, an expert on controlling odor. And of course, this is somewhat of a prelude to what Iowa has experienced since then, but this fellow had an idea of putting in a system of piping to essentially overwhelm the odor with perfume. And both sides really enjoyed that aspect of the testimony. I ended up ruling that the situation constituted a nuisance after hearing testimony from the residents of the little community about the difficulties that they were having breathing with the odor that was being carried by the breezes into their community. And there was no appeal in the case.
Well, there are some people who think we still ought to be using the nuisance law a little bit more than we are able to. Well, it wasn't too long before you were elevated to the Supreme Court. About how long were you on the district bench?
Just about 3.5 years, from July of 1968 until April of 1972.
Who had left the court before you?
Frank Becker. So I replaced Frank.
Well, you must have been one of the younger Supreme Court justices ever.
Yes, I did look at the book on that because people, particularly my local newspaper, kept saying I was the youngest judge ever appointed to the Supreme Court, but I didn't want to make that claim unless it was true. And I learned that looking at Iowa's Supreme Court history, there were 2 or 3 judges in the early years of statehood who were younger. And I think that partly was there weren't any old lawyers around, and it was a function of longevity and also education. There weren't that many educated people. But in this century, in the 20th century, I think I was the youngest to have been appointed. I was 38, and I told the members of the court when I met with them before being sworn in about the schedule of my swearing in, and I said I want to be sworn in before I turn 39. And Clay LeGrand commented to me, so did we all.
Well, I was thinking that when you who else was on the court besides?
Oh, my friend Harvey.
Right.
The Chief Justice was C. Edwin Moore, Warren Reese, Ward Reynoldson, Clay LeGrand, M.L. Mason, Larry Mason, Moke Rawlings, M.L. Rawlings from Sioux City, Dave Harris.
It occurred to me as I was thinking about this that in one sense you were from a different generation than all the other justices of the court. I mean, they were all people who, were mature in the Depression and through World War II.
Oh, it was a remarkable group. But Dave and I were really somewhat the young Turks. He was a few years older than I, but he had gone on the court about 3 months before I did. And we had known each other pretty well on the district court.
District,
yes. Right? Well, actually, we were in adjacent districts, but I had been in his court as a lawyer, and he had come over to Fort Dodge actually as a judge and tried a case that I was involved in, and I'd also known him on the district court. Actually, I was involved in the redistricting process, which brought Greene County, among others, into what is now the 2nd Judicial District. So before I actually went to the Supreme Court, we had enlarged our district, and I was getting into those areas.
Did it shrink the number of the districts down to?
Yes.
Down to 8?
Yeah, we went from 18 to 8. That was somewhat controversial at the time, but I actually was involved in trying to initiate that process. The court really did have some remarkable people on it, and I thought many times in retrospect that what was unusual about it is that they were people from diverse backgrounds, all of whom had had some unique personal life experience that prepared them, I thought, for the bench. I mean, I listened to Moke Rawlings, for example, talk about his struggle to get through college and law school economically, and admitting that he would go around early in the morning and steal milk money from folks that would leave the money out for the milkman in order to get something so that he could eat during the day. But he was a Depression product and a lawyer who had a great deal of experience as both a prosecutor and as a practitioner. Very wonderful human being. He was one of the few judges I ever met who treated prisoners as part of his constituency. I think he and Don O'Brien are the two judges that I've...
Something about the Missouri River.
Yeah, I've run into. They both happen to be from Sioux City. But Harvey, I had admired greatly. Larry Mason, I got to know. I thought he was a tremendous human being. He became somewhat of a mentor as well, and a good friend. Warren Reese, like my father, had taken the bar exam without having been to law school, and was a remarkable person with a great sense of humor. Clay LeGrand had a dry sense of humor, very bright, very capable, very confident in his views. And all of these people thought independently and I thought extremely well. The Chief Justice was a product of Des Moines, really. East side of Des Moines, very proud of that fact, and had worked his way up.
Some involvement in politics.
Yes, yeah, he'd been involved in the judiciary when it was in politics, and he had had a lot of political experience, which stood him in good stead when he was Chief Justice. In fact, one of the speakers of the Iowa House told me one time, pointed to him as we were in the State House. He said, that man is the best politician in the State House. The chief was good. And he was an excellent leader, good administrator, and just a wonderful human being. It was a group of people like I had never encountered before in this respect. I had noticed in almost every group I had ever been part of or ever had observed for any length of time, that it usually seemed that there were alliances or cliques with maybe one or two people being kind of the odd people out. But I never observed that on that court with that group of people, or even with the court as it changed over the years. That was one of the remarkable values of the experience, I think. Just seeing people who were all trying to do the right thing, were thinking independently, but were working together.
So even as a junior justice in several senses, you felt fully brought into the group pretty early on?
I did, and I went on with a view toward expressing myself. I had spent a lot of time reading opinions, and I had watched courts, and I felt it was important for people to think independently and to, as an appellate judge, make up their own minds and attempt to persuade others. And there were areas in the law that I really thought should be changed. This is an example of an area, was the so-called heart-balm statutes. And I had criminal conversation statute being an example of that, alienation of affections being another, and I had studied those things in law school, and I thought, this is just outrageous. These things should not be part of what is taken to court. And so I went on the court thinking that if there were an opportunity to refine the common law, as a common law court can do, that I wanted to participate in that process, and did. And so, and perhaps part of it was youth, but I ended up expressing views in dissent or in concurring opinions, some of which became majority opinions, maybe not right away, but later on, including that area of the heart-balm statutes. So that I felt I was accomplishing something, and I did participate, but I got along with people pretty well. I remember one time having circulated a somewhat stinging dissent, and having Larry Mason take me aside and saying, that's okay in an opinion that I write. If you want to write a dissent like that, he said, I can take it, and that's fine. He said, you wrote well and you expressed yourself. But he said, Judge X, who wrote the opinion in that case, it doesn't look at it quite the way I do, and I think you ought to soften that a little bit. So I did. I learned something. I also learned from Harvey Ulanop that dissent should never be personal. You can disagree on an issue without getting personal. He was a master of that.
There are one or two people on the United States Supreme Court that could benefit from that advice.
I think that's right.
Yeah. Well, that reminds me of a case I wanted to talk about sometime, because it was pretty early in your career. One of my law students got me involved in a flag burning case, and the student grew out of the demonstrations in Iowa City in the early 70s. We decided to challenge the constitutionality of the flag burning and flag desecration statute. Lost in the district court, and went up to the Supreme Court full of optimism that I had very good law on my side, and lost 8-1. You were the one, and you wrote what I thought was a very compelling dissent. Went up to and that helped me get it to the United States Supreme Court. And they sent it back for reconsideration, and it was still 8-1. And I always thought you had the better of the argument, and 20 years later the Supreme Court did too.
Well, I have to tell you maybe an inside story about that case. I do recall you expressing disappointment to me after the decision on occasion when we met. You were kind of disappointed in me because I couldn't get anybody else to go along. But I actually saw the U.S. Supreme Court vacate the decision, and it vacated the Iowa decision in light of a case that it decided called Spence against Washington, which was a flag-burning case that I thought also involved symbolic speech and really should have controlled the result in the Iowa case that you were involved in. But I was attending that summer after the case was remanded to the Iowa Supreme Court, what was called a senior appellate judge's seminar at New York University. Bob Lefflar from the University of Arkansas Law School annually supervised this seminar. And a U.S. Supreme Court judge would come up to the seminar, and Harry Blackmun came up that year, and he got talking about Spence. And he said, you know, there were a whole lot of flag cases that came along with it, and we vacated those decisions and sent them back to the states for reconsideration in the light of Spence. But he said, we don't really care what the states do in those cases now. We're not going to hear any more of them. So after you got the second 8-1 decision, which I thought was somewhat predictable, I was kind of hoping somebody would get dislodged, but no one did. And you tried for a second time to get the Supreme Court to look at it. They did what Justice Blackmun said they were going to do. They denied review. But I still think you were right, and as you say, you got vindicated later.
With a little distance, I can sort of understand the Supreme Court willing to only use so much of its political capital on that particular issue.
Well, it was
nice that we were both proved right.
What was interesting to me also, from a personal point of view, is that the decision was filed on July 3rd of I think it was 1973, and it was publicized in the Des Moines Register on July 4. Independence Day, Flag Day, or with the flags flying. I thought that was kind of appropriate too,
Yeah.
but and I expected to have a little bit of heat about that, but nothing really came of it.
I'm shifting gears here. Many of the Supreme Court justices stay in their hometown and only come to Des Moines for argument week and conference week. I think fairly early on you moved to Des Moines.
Yes.
Is there a judicial reason for that, or were you persuaded to come?
There were two reasons. One was a judicial reason, one was a family reason. We had a law library in Fort Dodge, which was adequate, but did not have the national reporters, and this was in an era before computer systems, before Lexis or Westlaw. So that research was a handicap or a problem, and I would have to stay in Des Moines if I wanted to look at books that we didn't have there in Fort Dodge. And the second reason was I had a young family. I had a daughter who was in kindergarten, and after a few months of going back and forth, we decided that we were better off moving closer to the books and closer to the job. So I did that, and there's some disadvantage to doing that. I can understand why people stay in their home communities, but I really could not have worked adequately without having made that move.
Maybe describe for the viewers just a little bit the work of a Supreme Court justice. I think everyone understands that you hear arguments and write opinions. What else is involved, and kind of how does the time break out?
Yeah. Well, for the Supreme Court, there are other responsibilities, which are administrative and rulemaking. That's apart from the listening to appeals, this preparation of opinions, and the conferences about cases. When I first went on the court, I believe that the decision-making part of the work, the deciding of cases, took perhaps 90% of the time, and the administrative work and rulemaking was 10%, if not even less. But we actually almost immediately, when I went on the court, particularly with some of the newer judges, we had Harvey Uhlenhop, who had only been on about 3 years, Ward Reynoldson, who had only been on a couple of years, Dave Harris and I, who rather quickly saw that there were some procedural changes that might streamline the operation of the court, and the workload was increasing. It took 23 months from the time that an appeal was prepared to get it submitted on average to the court for argument. We had just the one appellate court, and the court was sitting in every case with 9 members. So our first undertaking was to examine the court's procedures, and a number of changes were made in those first few years to divide the court into divisions and to try to improve the process. The oral argument time got shorter. There were some cases that didn't get oral argument. There was some experimentation with not writing opinions. And we got looking at rules. We worked on the Code of Professional Responsibility. We worked on canons of ethics for judges. Iowa had not adopted what at that time was a model code of judicial ethics. And there were a number of other issues, like the problems with lawyers mishandling client funds, the issue generally of keeping lawyers educated, as other professions had programs for continuing education. So we got into all of those areas. By the time I left the court, I would estimate that the court was spending about 1/3 of its time on administrative and rulemaking matters. And actually people, I think, often do not stop to think that the judiciary as an independent branch is governed by the Supreme Court. So it is a branch of government which has some governmental responsibilities, and that involves supervision of the lower courts. That also became a major activity.
And there are ways to do that besides just affirming or reversing their
That's right.
decisions.
Yeah, they're administrative responsibilities. And one of the major things that happened during the time I was on the court was the integration of the district court. That is, the creation of the Unified Trial Court, which had been an ambition of Harvey Uhlenhop, who had worked closely with the American Judicature Society for years. In fact, we had this judge in Iowa who was going around the country preaching the advantages of a unified trial court, but unable to get our legislature and our court to understand that it was a preferred way and a better way to be administering a court system. But that got accomplished during the period Harvey was on the court.
My grandfather was a mayor of Cedar Falls when I was a kid, and I remember going down to mayor's court. And I think I could testify that, wise as he was, this was not a good way to administer justice.
My father, in addition to practicing, was a part-time police judge in Fort Dodge. I never went to his court when he presided, and never saw it operate until I was back practicing law in Fort Dodge. But I had to handle police court every other week. I took turns with the county attorney. I saw how it worked, and while it depended on really the quality of the judge, I think, as to whether it worked efficiently and effectively and fairly, there were no rules, and there really was no system, and it was totally unpredictable. And I'd had the experience that all lawyers had had at that time with justices of the peace, and the people would comment that the title JP meant judgment for plaintiff. I mean, there were some justices of the peace that were just very arbitrary.
I think the record indicates that you wrote some 750 opinions in your tenure on the court, including the concurring. It always sort of seemed to me that that was more than most other people, and that you seem to draw more than your share of the tough cases. Now, is that accurate, or is the assignment process neutral? Or
well, the assignment process is neutral, but I can tell you two things, which I don't think are secrets. I didn't feel busy enough, and so I was volunteering for extra cases. I actually was trying to move the court to decide more cases than we had in our regular assignment system. And I thought we could do it if we treated cases more carefully, adapting our procedures to the character of the case. Differentiated case management is the concept. And so I thought if we improved our screening and even experimented with sitting in panels of 3, for example, but also took on more cases, that we could handle our workload. And the court did agree to sit in panels of 3, which we did experimentally for a time, and those of us who did it liked it, but it turned out the majority of the court didn't want to carry that on as an indefinite process. We experimented with making rulings, getting out rulings right after the oral argument in cases that we had screened as being relatively routine, and we did that, and some of us liked that, and majority of the court didn't go along with that, but it was part of that effort to get our court current and to keep feeling adequately challenged that I was volunteering for extra cases, so I would take an increased caseload. And that accounts for part of the fact that I ended up with perhaps more controversial cases. The other things that happened are that we had a couple of, perhaps a number of situations. I can think of 2 in particular where there was some urgency. We needed to make a quick decision. One was after the Court of Appeals was created. We had an issue as to the constitutionality of a district court judge serving on the Court of Appeals. And you would probably remember
Redmond
that.
versus Carter.
Yeah, as I recall, I think you were a nominee for the, weren't you, for the first Court of Appeals? Yeah. If we had ruled against the district judges, you probably would have had an entirely different career. But what we decided to do in that case, we saw the urgency of it, and I had looked at it, and I thought the outcome was pretty clear. And the result that should be reached, not just because I thought it was the desirable result, but because I thought the law and the Constitution supported that result. I was asked if I would handle the opinion in that case. So we ended up really within a period of about 3 weeks getting briefs and hearing the argument and deciding that case. We got that opinion out just a few days after the submission, and it was a matter of urgency. Another case, which is an example of that, is Head against Colleton, which was a case brought by Tom Riley on behalf of a client against the administrator of the University of Iowa Hospital seeking access to bone marrow data on behalf of a client who needed a bone marrow transplant. And so the issue really had to do with the confidentiality that the hospital insisted be maintained regarding its bone marrow. And that was another one that we put on a fast track because of the perceived urgency of responding to this particular plaintiff who had cancer and was deemed to be probably terminally ill. So, and I got involved in writing the decision in that case.
I think you had at least one other case where two pretty strong competing values of privacy on the one hand and sort of openness. The other one I think was a public records case.
Yes.
Case.
Yes. Yeah. And it happens. It's good.
Do you have a philosophy about that kind of issue?
Yeah, I think that I erred on the side of the First Amendment in those areas. And I was just going to tell you that one of my college roommates, a fellow named Dick Winfield, went off to practice in New York State, ended up as the lawyer in a Wall Street firm who represented Associated Press. He was very active in First Amendment issues. And I really didn't talk to him about the Howard case until after we had decided it, but I did see him in New York subsequent to that. And he was very pleased with that decision, but it was a decision where we held that a record in the hands of the governor under both, actually we just did it as a matter of statutory interpretation, was a public record, should be disclosed. It had to do with some nursing home records and a letter that had been written to the governor about the case. I also wrote an opinion, Green against the Iowa Athletic Council, which had to do with whether or not the Athletic Council at Iowa State University was a public body. I have to tell you, in the wake of both the Howard decision and the Green decision, the legislature made a couple of changes in the statutes to modify what otherwise would be precedent.
I'm familiar with the Green case for a couple of reasons. One, I was on the comparable body at the University of Iowa. And what they did is they affirmed your result and changed the statute so it would never happen to any other committee. So when I got to Iowa State, well, none of our committees are subject to the open records law except the Board of Control of Athletics.
We had another example of a legislative reaction to a case. I wrote an opinion once, and Dick Lyford, I think, would probably be interested in that case if he wasn't involved in it. It had to do with the sales tax issue, and I wrote an opinion in a particular way that I think said that the tax was applicable to a particular kind of sale. And the fellow who was in the leadership in the Iowa House came storming in after that decision to the Chief Justice's chambers, and C. Edwin Moore was Chief Justice at that time, telling him what an awful decision that was. And the chief told him, well, we were simply interpreting the statute. And it was a unanimous decision. But during that very session, the legislature had a very narrowly drafted and targeted amendment to the statute. They took care of that one, too.
Well, that's part of the judiciary's job, is kind of educating the legislature on how to write statutes.
Exactly. And really, it is impossible for a legislative body to anticipate every potential application of a statute, as you know, and that's why judges get accused of legislating sometimes when all they're really doing is doing what Holmes described as legislating interstitially. They're filling gaps.
Jump around here a little bit. I ask you about the helpfulness or not of law clerks to you, whether you're replicated the experience you had with Harvey Johnson.
Yes, I used law clerks, but not the way law clerks are used today, and probably not in a way that most judges would consider the most effective way. But for me, it was the most effective way. I used them to examine the briefs on an appeal and to do independent work and independent thinking, and then give me a memorandum about the case, and then talk about the case prior to the time that it was submitted for decision. I did not ever have a law clerk draft an opinion, a draft opinion, and that's a topic on which I've got very strong views still as I listen to U.S. Supreme Court justices talk about their practices. I tried one time when I had a law clerk memorandum on an issue to incorporate language that was in that memorandum, because it was a good memorandum and had a point of law researched and then stated, followed by a string citation that was a good list of authorities supporting the proposition. My first draft of the opinion, I put in the sentence and I put in the string citation, and then I got looking at it and I thought, that isn't the way I would say it. And so I did what Harvey Johnson had done to me. I said, you did a nice job, that isn't quite the way I would say it, and so I've made this change. I think I worked fast enough, perhaps too carelessly in some people's views, that it would not be useful for me to have law clerks do drafting. I ordinarily put opinions through just one draft and then one editing. And then, of course, you might make changes later as other judges would comment on things. But I got involved in running during the period I was on the court. And what I found very effective was to get an opinion through an initial draft in the morning, go to the Y, run anywhere from 5 to 10 miles, go back, and while I was running, think about that case and the changes that I really ought to make in that draft, and go back then to the Capitol in the afternoon and sit in my office and do the editing and put it through that second draft, which usually was the last draft I would do. And that was not terribly time consuming. I was, at that time, again, subject to criticism in a different way than a lot of other people probably worked. But I would spend probably an average of a day on an opinion. That's in the writing process.
The memorandums from your clerks made me, I wanted to go back. Am I right that the Iowa Supreme Court, your case assignment process, it assigns it to a justice before the argument and the conference rather than after, like the federal courts?
Yes, and I understand that's still the practice.
What are the pros and cons of that, do you think?
Well,
I've looked a little bit at both sides.
As I understand, the people that support that proposition believe that you get a more thorough review and study when the judge who's going to write the opinion knows in advance that that's the case that he or she will be writing. And so that judge comes to the conference after the oral argument, goes to the oral argument better prepared perhaps than the others, and also comes to the conference after the argument in a position really to be very helpful to the other judges who theoretically have looked at the same papers but not as intensely and have not had the independent research done in most cases. As I anticipated, at least I think those are the arguments that people would make in support of that system. I didn't like that system and don't like that system. The other system is the one that's used, as I understand, on the Iowa Court of Appeals and is used on the federal circuit courts for the most part, and actually on the U.S. Supreme Court, which is to wait until after argument to assign the case to a judge. And that hopefully will make all of the members of the court better prepared when they go in to argument, because no one knows whether he or she is going to end up with that case in advance. And so there's a better chance that all of them will have looked at the decisions. I've been accused of having said about the Iowa Supreme Court that only one judge really looks at the case. I have not said that, but I have said at a seminar on one occasion, and this is the quote I think that's being used against me. What I said was that oral argument is the only time that you are really assured that you have the attention of the people that will be deciding the case, because the level of preparation for an argument differs among judges. And I know from experience that judges come with different levels of preparation. So requiring everyone or having a system where everyone will be prepared for oral argument in the decision of the case, I think is a better system, the so-called hot court system.
In using your law clerks do memos on all the cases or just the ones that you were assigned?
They would do law clerks on the ones I was assigned and on cases that I was interested in, where I would ask them to do work.
I want to go back to judicial administration a little bit and ask you to talk about the most significant changes in the court system while you were in the court, and maybe that's the creation of the Court of Appeals, I don't know, or is there some other changes that you think were more important?
Well, in the changes in the system, I think that is structural change that was very significant, which I opposed at the time. Didn't think it was necessary. But the adoption of the Unified Trial Court, the adoption of the statute taking the clerks of court out of politics, which was really part of that unified court change. That was a major change. Those are the main structural changes. The main administrative change was adopting the system of judicial administration involving the chief judge system, with a state court administrator working with the chief judges and working with court administrators in the judicial districts. One has only to have practiced under the previous system to understand what we take for granted today was so necessary. When I started practicing in Fort Dodge, if you wanted to try a case, you had to have the agreement of the other lawyer. Unless you had an aggressive judge who, on his or her own, would just say, you got to get this case tried. But we'd meet as a bar in the courtroom and have the district judge go through the calendar of pending cases and ask if the case was ready for trial. And if one of the lawyers said no, it wouldn't be put in the assignment. So the whole system of judicial administration is a phenomenon that originated in Iowa in about 1970, and from that period on, and it has gotten much more refined and sophisticated. And that was a major, major change in the way things were done. In the rulemaking area, of course, the court was very active, adopting a requirement for continuing legal education, setting up a system, establishing the client security fund system as a means of protection of clients, adopting a system with respect to attorney disciplinary cases of writing opinions in every case in which discipline was imposed, and a number of things of that kind. Having a system of screening cases after the Court of Appeals was created to transfer cases to the Court of Appeals as was appropriate.
Disciplinary systems aren't always real popular with the bar, but what's your sense of whether all that has changed the way law is practiced in Iowa?
I think it has. It's probably been more of an incremental change, but I believe it has raised the level of sensitivity of lawyers to ethical issues. I know from experience that things happened that did not result in discipline prior to the time that the disciplinary system was sort of energized. And that's something that happened probably pretty much in the 70s at the time the court started publishing disciplinary opinions and started to professionalize the system. And it's been more professionalized since, and it's now under the auspices of the court itself rather than the Bar Association. And I think by and large that those changes have helped. I think they've raised the sensitivity level of lawyers and have refined, I think, practices for the most part. There's still, of course, a lot of problems, but the system is better.
I meant to ask you earlier when we were talking about your district court experience whether you were there long enough to get reversed by the Iowa Supreme Court. Did that happen to you?
It did not happen to me while I was still on the district court, but it did too. It did, yes. Child custody case got reversed. And that was the only one of the several decisions that got appealed in which I was reversed.
Yeah. well, there's in talking about judicial selection, there's pros and cons of trial judge experience, but is one of them the notion that it feels like you need to know what it feels like to be reversed?
That certainly would be part of the process, I think, and sort of an advantage, perhaps, that district judges bring in the way of experience. They know what judging is about. And really, you know, one of the things that, again, even lawyers aren't fully aware of is that judging is different than lawyering. It's different from lawyering. And the fact of the matter is that some very good lawyers make poor judges. And some fairly mediocre lawyers make tremendous judges. The qualities are different, and the sense of responsibility in the position and the understanding of what it entails. And so I think one advantage district judges bring is that they're a proven commodity for good or ill, and they can be evaluated perhaps on their ability to do judging.
What do you think are the most important qualities in a good appellate judge?
A sense of the importance of the integrity of the judicial institution. I think that judges should be thinking of that all of the time. That is, maintaining the integrity of the system itself, the rule of law and their role in it. Beyond that, I think, is the interest in the scholarly side of the work, doing the work that's necessary in order to make an evaluation of how a case should be decided, and diligence, the willingness to work as hard as is necessary to get the decision made, certainly some writing ability. I think it is tremendously important that a judicial opinion be crafted carefully, as narrowly as possible, to decide only the issue in the case, to decide it clearly, to communicate clearly. So those are all things that are very important. And even though an appellate judge is not dealing directly with lawyers except during oral argument or with the public as a trial judge would be, as a general proposition, temperament is important, because it's important to maintain the collegial process with the other judges. And that can become, as you know, when you're arguing with people for a living, in the decision-making process, it can become contentious, and you have to be able to handle that carefully.
Let's use that as a little segue. As we're doing this interview, at the United States Supreme Court level, we're just gone through one confirmation and we're about to go through another. And there's a great deal of talk right now of separation of powers issues, which you confronted several times at the state level. Federalism, which state justices feel sometimes, and so-called judicial activism, judicial restraint, emphasis on stare decisis. Any of that conversation provoke comment from you in terms of being right or wrong-headed?
I have to tell you of an experience where, as a district court judge, I overruled an Iowa Supreme Court decision. I had a case which involved the issue of governmental immunity in the law of contract. The government had made a lease with a private company and then broke the lease, or at least allegedly broke it, and caused an action to be brought by the private entity against the department. I think it was the Iowa Department of Social Services, might have had a different name at that time. And the issue was whether or not the common law defense of governmental immunity would apply, sovereign immunity, and insulate the government from its liability under the contract. And again, as part of, I think, my impetuousness and a product of youth and independence and stubbornness, I wrote a decision abolishing governmental immunity in contract cases. And that's against the background of having in private practice handled the case Boyer was the name involved in it against, I think, against the state board, in which I had relied on governmental immunity in a tort situation. But in any event, in that case, in fact, the party was Kirsten, the plaintiff. I changed the law at the district court level, and that case came before the Supreme Court after I had become a member. And so I did not participate in any way, and I left didn't participate in didn't listen to the argument, didn't participate in the discussion of the case, but I really saw some kind of fish-eyed looks from my colleagues about that case, and it resulted in an opinion written by Clay Legrand, where he severely chastised me for taking it on myself to reverse a precedent of the Iowa Supreme Court, but then proceeded to abolish governmental immunity in contract cases. Said even though I shouldn't have done what I did, the result was correct. I should have left it for them to do. So maybe I was just trying to avoid reversal because I was predicting that it was time the court looked at that and that it might change its view. So that was an example of, well, let me tell you, another significance of that case is that something the public is not totally aware of, and that is the role of a common law judge. When there is discussion of judicial activism, you have this image of judges not following the Constitution or not following statutes, departing in some way from what folks, I think, sort of imagine is sort of a straitjacket created in the Constitution or in statutes that judges depart from in some cases. And certainly there may well be some situations where judges stretch in their interpretation of either the Constitution or a statute, which is controversial and certainly subject to reasonable differences of opinion. But people are not aware that judges have a responsibility in a common law court to make law. And it's part of our Anglo-Saxon system, our system of precedent, that in the non-statutory and non-constitutional area, we are dealing with judge-made law. And so courts need to re-examine it, and it is their responsibility when it needs changing, when it does not suit the times, to be ready to make the modifications of the law that are appropriate in the common law system. I've had federal judges tell me they envy state court common law judges because of their ability to work in those areas, actually to decide for themselves whether the judge-made law that was made in 1856 is appropriate in 2005 or in a subsequent era. So the judges do make law. They have to make law. That's part of their responsibility in that area, in addition to acting interstitially in the statutory and constitutional cases. There was an incident one time where we really had particularly to exercise our view of separation of powers that involved a confrontation over an administrative issue with the Iowa General Assembly. This was when C. Edwin Moore was Chief Justice, and the legislature became concerned about its lack of adequate space in the Capitol. And there had been periodic rumblings in the legislature about moving the court out of the Capitol and into some other building or some other facility. And first, we wanted to stay where we were. We were very proud of the courtroom that had existed in our state capitol since its construction. And the facilities that we had been remodeled, actually, and restored during my early years on the Supreme Court. And so we really felt quite comfortable there and didn't think the legislature had a right unilaterally to decide to put us somewhere else. They at least ought to be talking to us about it. And so the Chief Justice scheduled a meeting with the leadership of the legislature in our conference room. We invited them to our turf. In advance of the meeting, we prepared a memorandum on the separation of powers which everyone on the court reviewed and approved. So at the meeting, the chief presented this memorandum to the legislative leadership and told them we were not going to move. And we didn't move. So that's an example of the Judicial Department as an independent, co-equal branch of government asserting its muscle. And of course, if there were a confrontation that had to be resolved in some way, it would have been very difficult with the two branches at odds with each other. There probably would have had to be a judicial solution ultimately.
But sometimes the judiciary is called upon to referee separation of powers issues between the executive and
Sure.
legislative branch. The language in the Constitution typically about that is both general and Delphic. Any particular thoughts about how one should approach those kind of situations?
Yeah, I think that they have to be approached carefully and sensitively, but there is precedent, and the kind of case that kept arising that involved tension between the executive and the General Assembly when I was on the court was the interpretation of the item veto provision of the Iowa Constitution, which of course was uniquely an Iowa provision. And the court really had to interpret what the people intended when they adopted that amendment, and the court sort of felt its way through that process, and there were cases where the General Assembly prevailed and there were cases in which the governor prevailed. And so I think the court appropriately took on that difficult task, but I think also was very sensitive to the importance of the decisions that were made in those cases. There was a time, really while I was on the Supreme Court, where judges were being educated about the inherent power of courts. And that particularly was a product of going to the National Judicial College at Reno, where a lot of trial judges go for orientation after they are appointed. And there was a course there on inherent powers. So there were situations where judges who were educated to that power and authority sometimes exercised it, maybe inappropriately, but that has subsided considerably.
After a decade and a half or so of service on the court, you decided to leave the court and return to private practice. I recall that came both as a surprise and a disappointment to me and a lot of others, I think, because of what you brought to the court. Would you mind sharing this with us, what went into that decision?
Sure. It was not an easy decision to make. Actually, I got a call one day from David Bellin, who told me that he wanted to come over and talk to me. I had no idea what about. But actually, when I had been on the district court, I had been asked on a couple of occasions if I'd consider leaving and going into practice with firms, not Fort Dodge firms, but other firms. And when I had been on the Supreme Court, I actually had been approached by another lawyer who had told me that he would like to have me consider leaving and joining his firm, and I had just rejected it out of hand. I, at that time, did not want even to get into thinking about it. But David came over during the summer of 1985 and told me that his firm was looking for someone, and he thought that they needed someone with the kind of background that I had, and would I be interested in leaving the bench and joining his firm. And he told me a good deal of things about what kind of work the firm did and about the firm and its people. And I told him I would think about it, and he got very enthusiastic and even set up a meeting that I was to have with the firm at his house, sort of a social gathering, so I could get acquainted with these people that I would be joining if I left the bench. And I got thinking about it, and I talked to my spouse, and I did what people sometimes do. I mentally made a list of what I liked about what I was doing and what I might be attracted to in the practice, and sort of weighed the issue of change. And I decided I want to stay where I am. I like what I'm doing. And so I told David that. And people that know him know that he was nothing.
An easy person to say no to.
He was, if nothing else, he was persistent.
And he was more than that to you.
So he came back and said, I know you turned me down before, but I'd like to have you think about it again. And I got thinking, I think I was 51 at the time, and I got thinking about how many more years I would have on the bench if I stayed there and lived. And it would be 21 years because mandatory retirement would occur at age 72. And I got thinking about what I was doing and sort of made that mental list again, and then thought about the practice and the idea of doing something new. It would be in a different city, a different kind of law practice than I had done before. And I would really be tested. I had seen T.G. Garfield, when he left the Supreme Court, come back to practice in Ames. And he had been on the Supreme Court, I think, for 29 years at the time he left. He came back into practice and was terribly handicapped by having been out of touch for so many years. So it didn't work very well. So part of the equation that I was looking at was, if I was going to make a change, I didn't want to wait till I retired. I didn't want to wait 10 more years. I should really do it at the time. So I got thinking about the court's work, and we had been through a lot of exciting times with sort of implementing the Warren and Berger Court changes in constitutional law in Iowa. We had been through the Administrative Procedures Act and a good deal of the decisions necessary to implement that statute. We had been through the new criminal code, which had been adopted in 1978 and had interpreted many of the unusual provisions and unique provisions of that statute. We were really at a point where our work was becoming more routine, and a good deal of the work seemed the same. So I got thinking about that, whether the challenges would be the same. And the things that I had really wanted to get accomplished when I went on the bench, such as some of these pet peeves, like about the Hart-Balm statutes and about contributory negligence, those changes had been made. And the guest statute we had held under the Iowa Constitution to be unconstitutional. And it seemed that there was not all that much more prospectively that would be as interesting as the past had been. So, but I was afraid, really, because I was thinking of the Justice Garfield experience and wondering whether I would make that adjustment. And I was realizing if I went back into practice, I would once again be at the mercy of judicial decision-making in the practice of law, because there's no control over outcomes. And the great advantage of being a judge is that you make the decision, even at the district court level. And if you're not terribly concerned about the potential for reversal, but just want to do what you think is the right thing and do your best, that's a tremendous feeling, that the responsibility of being objective, being able to look at a problem and then resolving it. The other great thing about judging is that you see the beginning and the end of problems a lot sooner, because you don't see an appeal until all the work has been done in preparing it. The process of taking it under submission and deciding it is a relatively short-term process. And I knew from past experience how long it took to get things through the process at the trial level for lawyers, and also all of the frustrations along the way. There have been a lot of changes in discovery in the years I had been on the bench. I hated written discovery and what was happening with the explosion of paper in the law practice. So I was looking at those things as being the downside, and the lack of control over outcomes was a major factor. I wondered if mentally and emotionally I could take losing a case after having been in a position of deciding cases for this period of time. So I actually talked to, particularly to Harvey, who's a confidant on many things, and Harvey Uhlenhop, and told him what I was thinking about. And he really pretty much said I had to make the decision myself, but he told me that I had to be able to look at a case as a lawyer, as a file, and not as a cause. And he told me, in practice, a problem separating himself from the cause. So I took that to heart and had that in mind. Would I be able to do that and not feel bad when I got an adverse result or when I got frustrated? I had the feeling one has when standing on a high board at a swimming pool and about to dive into the water. Should I make this jump, or should I stay with something that I'm very comfortable with, that I like a lot, but which I probably would stay with for 20 more years? And I actually had what I've described to people that have asked me about it as kind of a suffocating feeling. I felt, no, I think I want to change. And so I did decide that I would do that. I then explored meeting with people in the firm and made that change. And I've not regretted it. One of the best pieces of advice I ever had from anybody came from Harvey Johnson when I was telling him I was going back to Fort Dodge to practice. And first he told me two things I guess I should mention. One is, don't look back. He said, when you make a decision, just proceed ahead, full speed, and you will be so much happier with your decision than if you start thinking back and weighing your decision again. The other thing he told me, which I never forgot, was, I think you might be thinking about wanting to be a judge. If you ever want to be a judge, be a district court judge, a trial level judge. Don't be an appellate judge. He said appellate judging is a monastic life, and it is so lonely. And you're so much better off if you're interacting with people as you are at the trial level. So I had that in mind when I got on the bench. But I did particularly remember his advice not to look back when I came back into practice. And I worked as hard as any beginning lawyer, I think, in the practice to try to get up to speed, and haven't looked back and have enjoyed it a lot.
You're just talking about transition to private practice, and I found myself wondering whether the fact that you'd been a Supreme Court justice has affected the nature of your practice in important ways.
I think it affected both the nature of the practice and the style of practice, in the sense that, or my ability as a lawyer, because I had the experience of having been a lawyer involved in a general practice that involved a full range of issues and experiences, and then had been on the trial bench and then had been on the appellate bench. Each of those situations gives one a different perspective. And then getting back into practice again, I brought those perspectives with me, and I think it has helped in the practice because I can make, I think, much better judgments than I would otherwise be able to do about how to handle cases, predicting what arguments work and don't work, how to make them, and predicting outcomes. And I can do it regardless of whether I know the judge involved.
Or even whether you decided that way yourself.
That's right, that's right. But my first question when someone tells me about a case that they want me to get involved in, which sometimes happens after it's in process, is who's the other lawyer, who's the judge? And as you know, that makes a tremendous difference. And so I've learned to kind of weigh those things. But I think the perspective of the judicial background has been very helpful. What I found happening soon after I left the bench was that I got asked to handle an appeal, which had already been briefed but not argued yet, by a client that wanted me to become the lawyer for that client. And they had their reasons. But I thought this was a good opportunity. But it would involve an appeal, and I had only been off the bench about a year. And so I was very sensitive to whether I should be going back in front of the court in an appeal. And the more I thought about it, the more I decided that there really was not a problem with it so long as I didn't try in any way to take advantage of my knowledge of the court and its practices. So I did decide I would do appellate work. That was part of the decision. And then I decided I would do that case, which was really a matter of timing. And so I have done a substantial amount of appellate work since I left the bench. often with cases that have been lost at the trial level that are relatively difficult appeals. And I have thoroughly enjoyed that experience because it is challenging. It's problem solving. It's an effort to make something out of a problem, to find a solution to it. So I have thoroughly enjoyed the appellate work that I have done. I've always enjoyed advocacy, and so that's been a part of my practice, both at the
clients come to you wanting you to resolve their disputes? And
yeah, that's another thing that's happened, and it of course is a sign of the times too, because of the emphasis on alternative dispute resolution, mediation and arbitration. I was asked early to get involved as an arbitrator in some disputes, and that really was before mediation had taken hold. But I was asked, or given an opportunity to compete for an appointment as a co-mediator in a series of cases down in Kansas City involving the National Farmers Organization and some farm cooperatives that had been festering for about 25 years, going through the courts up and down and horizontally spreading to different issues. And I was actually approached by a fellow down at the University of Kansas City at Missouri Law School, who was a native Iowan. And he said, I'd like to have you and Dick Calkins. Dick had left Drake, deanship at Drake, and was trying to get involved in mediation. He said, I'd like to have you make yourselves available as two of the applicants for this potential appointment. So I visited with Dick about it, and we did say we would be willing to do that, to undertake this mediation. This was quite a while ago. It was good 15 years ago, I believe. And so we did present our names, and the professor had told us he didn't expect we would be appointed. He thought the judge would pick somebody local. But Dick and I were selected to do that mediation. And I learned a lot during that process, particularly from Dick, who had been through it before and had been through training. So we co-mediated that process over a period of several sessions and ended up, mostly through his efforts, resolving this 25 years of litigation. And it was such a good feeling to have participated in the solution of something that otherwise would have involved substantial continuing expense for the parties and problems for the courts in terms of consuming the docket and judges' time. So after that, Dick would recommend me occasionally as a mediator when he had a conflict or another issue. So I've gotten involved in mediation. I don't hold myself out as a mediator. I simply get called on occasionally to do it. I would estimate it has never amounted to more than about 10% of my practice. I had the good fortune of practicing with Roger Stetson, who was one of the pioneers in mediation in Iowa. And Roger ended up, before his death, spending probably more than 50% of his time on mediation. He was a wonderful mediator.
A few cases for us.
Yeah. But so I did that. I did some arbitration. I've been working as an arbitrator for the National Arbitration Forum, which really mostly involves kind of routine arbitrations, except that they have gotten into the issue of domain name disputes now. And so I am a panelist who will decide either solely or as a member of a three-person panel a dispute among people competing involving a website domain name that's been registered, alleging that somebody else has infringed on it. It's very much like the traditional.
You'll become a techie here when you get
Yes, I'm beginning to understand what goes on, and I've had enough other experience trying to figure out how the web works, that the internet works, that I understand that. But that's been fun. So I've done that.
One other thing I know that you've done that may be different in that respect. I know you've been in federal court occasionally since you. Has that been a different experience in any significant way?
It has been. I have to tell you, my first experience in federal court was helping my partner Jeff Krausman defend an employment case within 2 or 3 months after I left the bench, and Judge O'Brien was presiding. It involved an issue of whether or not a fellow that had been activated in the Guard was treated fairly after he came back from active duty. And Jeff and I were defending the case, and I made our motion on behalf of the defense for directed verdict. And I said, comes now the court, and moves for a directed verdict. I was having a little trouble with my vocabulary on that. I don't think Judge O'Brien caught that, but I realized as soon as I said it that I had misspoken. That was a baptism of fire, and but it was good to get involved just immediately in a trial. I hadn't had to work on the preparation for it. I just got to participate in the trial. In that fall, I got called by a Chicago lawyer who had been referred to me by a law school roommate as being someone that could possibly handle a case in Iowa. It involved a failed transaction where the contract had been made to purchase a business, but the closing had failed. And I was being asked to get involved on behalf of the defendant in defending a specific performance action for the sale of this manufacturing company in western Iowa. And my witnesses in the case would be 6 lawyers who were involved in the transaction. Most of the adverse witnesses would be lawyers too, but I knew how poor witnesses lawyers can be. So but we had an urgency about it because it was 1986 when the Reagan tax reform statute had been passed, and there was a doctrine called the General Utilities Doctrine that was going to be effective the first of the year. So I was called in October. If we lost the case and my client had to sell the business, there'd be a tremendous adverse tax consequence. So the Omaha lawyers that were on the other side and I agreed to ask the court for an expedited schedule. And we prepared that major piece of litigation in 6 weeks by doing all the deposition work and pleading work that needed to be done to get ready for trial, and tried it to Judge Richardson, who understood our problem, James Richardson, and accommodated us and assured us that he believed he could get a ruling out before the end of the year. So that was a fast-track experience that was tremendously beneficial too. But the thing that you're talking about that as to changes or the evolution of the practice that occurred that I think is fairly significant is that I was called to get involved in a disciplinary case 4 or 5, well, maybe not that long, maybe 3 years after leaving the court. And I had never, of course, been involved in one except at the decision-making level, the appellate level, but agreed to take this one after visiting with the lawyer involved. We had a hearing and we were successful in that proceeding. And there aren't, as you know, very many lawyers that do disciplinary defense work. I think the main other lawyer that I knew that was doing the work was Lee Gaudinier, who was a good friend of mine. And I really was not looking for that kind of work, and even to this day do not look for that kind of work. But things started happening where gradually more and more of that business started to come. And so I have had a large number of disciplinary cases. Probably that's another 10 to 15% of what is my current practice, and with some frequency get called on for opinions on ethics issues, both within my firm and by lawyers generally. The thing that it taught me that I had learned because I had the judicial background was that the system wasn't working very well. And it was pretty obvious what some of the problems were. I had been on the court when what was then Court Rule 118 was adopted, and we had made some changes in the system in an effort to professionalize the system and streamline the process. But there were a lot of problems that I had encountered in practice that I knew the court had the capacity to fix by changing rules. And I knew what that process was, so I called the Chief Justice, it was Chief Justice Lavarado, at the suggestion of one of my partners. In fact, Roger Stetson suggested I do it because he'd had an experience too where he was dissatisfied with the system. So I called the Chief Justice and I said, I think the court should look at possibly changing some of the rules. And he said, I think that's a good idea. And he had Bill O'Brien call me subsequently and said, would you chair the committee that's going to examine the disciplinary system. So I got involved in that process, and the background of having worked in the system at the level that I had and actually changing some of the rules when I was on the court helped a good deal. And the committee was a diverse group of people with good ideas, including representatives of just anyone that would be interested in that kind of activity, people that had worked in the system. And we came up with some changes, and sensitive to the fact that so many reports end up just gathering dust, we had some concern about that we submitted to the court, and the court, as is typical, took some time before implementing some of those changes, but it has, and it has some others that it's still considering. I guess the other main area in which I've had some heavy involvement is some of the extracurricular activities that I've been asked to get involved in by public bodies. I got a call 3 years after leaving the court from Bob Arnold, who at that time was Speaker of the Iowa House, saying that in the wake of some problems that legislators had had with some ethics issues, the legislature thought it should study the question of adopting rules that would govern, perhaps statutes governing the conduct of people in public office, public bodies. I think the Iowa Trust problem had been created or existed. And well, I had also been involved in what has been referred to as the Mingo incident. The House Ethics Committee had asked me to serve as lawyer for the committee investigating whether a legislator should be disciplined as a result of that incident. And that had happened before 1989. That's probably how Arnold knew me, and I'm sure he was thinking of the background that I had, and asked if I would serve with Art New, who was the former lieutenant governor practicing in Carroll, and I thought that would be fun to do. And so with Art, chaired a group that was, again, diverse, had some remarkably able people on it, including Bob Albee, my former colleague on the court, some people who have been very active politically were in the group, and a lot of people interested in the rule of law. So we made some recommendations to the legislature about some statutory changes, some revision of the gift statute, among other things, and really recommended also the establishment of a state ethics commission or board to supervise executive branch ethics matters. We knew the legislature would supervise its own, as it always had. And a good deal of our recommendations were implemented by statute. And then I was asked to serve on a subsequent committee as chair of a group that was working on revisions of that statute. So I got involved in that, serving almost totally with legislators in that group. There were a number of legislators who were lawyers and some were non-lawyers on that committee, and we recommended some changes in the statute. One of the changes that got made was to establish a state ethics board as an addition to the responsibilities of what had been the Campaign Finance Disclosure Board, and that has functioned ever since. But those things have been satisfying experiences. Governor Branstad appointed me to a couple of task forces. One, to look at changing the public investment statute in the wake of that Iowa Trust scandal, to try to assure that that sort of thing did not happen again, that public fund investments were safe. And I worked on that group, which came up really with a proposed statute that was adopted by the legislature with only a couple of changes to accommodate certain interests the legislature wanted to serve or accommodate. That was a good experience. Then the governor, again, Governor Branstad asked me to chair a task force to look into the public institutions and to determine whether what changes should be made regarding their functions and futures. And that, of course, because that was something different, and it was not something one runs into every day in the practice of law, just like these other committee and task force experiences. It was just tremendously enjoyable and challenging. And we looked at the state institutions, the hospital schools, and the other institutions, and the hospitals themselves, and identified problems and issues that would have to be confronted. And so it was a broadening experience. We made a report Actually, our report basically was that there should be changes, but the changes should not be to eliminate institutions, but to concentrate on creating specialized treatment facilities as opposed to eliminating the institutions. So I really have thoroughly enjoyed those things, and I do think the experience and the background on the bench has been a valuable preparation for some of those things.
To conclude here, let me ask you to do this. Going back to your career as a Supreme Court Justice, is there one case that you would identify as perhaps having the most lasting impact on the law in Iowa? And are there any that you would decide differently today?
Yeah. In terms of the case having impact on the law, I think there probably is one, though I would have to leave it to others to decide whether there is some other case that's more significant. But this was something, again, that I had brought with me out of my practice experience. I was amazed when I came back to Iowa to practice with our contributory negligence rule. It was a common law rule. It was judge-made. It was not legislated. And it was the rule that said that part of a plaintiff's burden of proof in a negligence case was to prove that the plaintiff, proved by a preponderance of evidence, that the plaintiff himself or herself was not in any way or any manner responsible for the incident on which the action was brought. So it meant really if the fault was 2%, the plaintiff's fault, and the plaintiff was unable to negate fault, the claim was barred. And there were cases that were being thrown out with adverse results for plaintiffs where there was probably a very minor responsibility in the plaintiff for that fault. And I had had cases in practice on both sides of that issue. I had defended cases and I had been representing plaintiffs. But no matter which side I was on, I loved the rule when I was on the defense side in terms of arguing to a jury. But in terms of the justice of the rule, I thought it was atrocious. And Iowa was out of step. There just wasn't any state that had the same rule. So I became a critic of the contributory negligence rule. Others were critics too, and the legislature made a change. They actually adopted a contributory negligence statute which took the burden of proof off the plaintiff, put the burden of proof on the defendant to prove the plaintiff was somehow at fault to some extent or in some manner, but still had it as a complete defense. There was wiggle room, however, because the statute only addressed the issue. They did not in the statute make it a complete defense. What they did was shift the burden of proof and said that it had to be demonstrated that contributory negligence was a proximate cause of the incident. So they did not actually address in the statute the issue of the effect of contributory fault. So I got looking at what other jurisdictions were doing and also what other jurisdictions were doing just by case law, and found that in about 5 states, courts, as a result of working with the common law, had changed their rule to what was called pure comparative fault, which would involve apportioning responsibility and apportioning an award based on the relative fault. And so I started, when I was on the appellate court, questioning the then common law rule of making the contributory negligence a complete defense. And I, in at least one case, dissented, might have been 2, suggesting that we needed to change the rule when it was being applied in a case where it did not seem to be fair under the facts of those cases. And I just began to oppose the rule. And what amazed me was that by 1983, when we had a case involving that issue in the context of a medical negligence case, Getzman against Wichern, I drew the case. It was assigned to me in advance of oral argument. So I knew I was going to write an opinion or a dissent, an opinion and dissent. But I proposed to the court that we change the rule. And it resulted really in other members of the court agreeing. The court was not unanimous. I'm not sure whether it was 5-4 or 6-3. I think it turned out, I think it was 5-4. But we did adopt, by our common law authority, a pure comparative negligence theory. And I felt that was because I had the experience in practice and on the district court of seeing how unjust the previous rule was. I just felt that that would make justice better for people involved. And it was not a hardship on people defending cases because their responsibility would be apportioned fairly just in proportion to their fault. But it did cause an uproar. Not so much an uproar in the bar, because I think the bar sort of liked the change. I know I would have if I had been a lawyer at that time. But there was concern in the insurance industry in particular, and those interests which were involved in defending cases. So the legislature ended up modifying our pure comparative negligence rule by a statute which really retains the pure comparative negligence theory up to the point of 50%, and then provides that if the plaintiff is...
Accepted your basic...
Yes,
really.
yeah, which was really okay, and I've worked with it after leaving the bench. But I do think that was an appropriate thing for judges to do, and I think it has made our legal system better.
I think so. Hey, thank you.